morning, everyone. Thank you so much for joining our June webinar on PERB Informal Settlement Conferences. My name is Kimberly Procida. I'm a senior regional attorney with the Office of the General Counsel here at PERB. I've been conducting informal settlement conferences for about 8 years now, and I've seen a lot of different situations. I've seen a lot of successful informal settlement conferences, and so I hope that this information in the webinar will help you have a successful informal settlement conference of your own. Today, we're going to be answering 3 questions. First, what is an informal settlement conference? Second, when does an informal settlement conference take place? Third, what happens during an informal settlement conference? And after we answer those questions, we're going to go over some best practices for preparing for and participating in an informal settlement conference. Before we get started, I do have to provide a brief disclaimer because it wouldn't be a legal presentation without a legal disclaimer. So please note that the views expressed in this presentation are those of the presenter and are not PERB's official position on any matter. This content is for general informational purposes only. This information is not legal advice. Some statutes that PERB administers have unique characteristics that may differ from the general principles discussed here. Please refer to the specific statutes, regulations, precedential decisions, or other legal authorities as appropriate. If you'd like to see the statutes that we administer here at PERB, look at PERB's regulations, or read over those precedential decisions, you can find those on PERB's website. If you have any questions about this material or PERB's process, you can send an email to us at perbquestions@perb.ca.gov, and we'll get back to you. All right, first up, what is an informal settlement conference? An informal settlement conference is a confidential mediation between parties who have a dispute before PERB. So essentially, we have parties who have an open case here before PERB. They have some sort of labor dispute, and a PERB mediator is going to come in, bring those parties together, facilitate discussion between those parties to hopefully get them to a resolution. Now, I said that these mediations are confidential. This means that PERB's informal settlement conference proceedings enjoy confidentiality pursuant to California Evidence Code Section 703.5 and 1119. What this means is that no statements made during the mediation or any writings prepared for the mediation can be used in future proceedings. So let's say that the dispute doesn't resolve at the informal settlement conference, and this case moves on to a formal hearing before a PERB hearing officer or an administrative judge. Anything that is said during these mediations for the purposes of settlement, any written settlement proposals, those can't be brought up as evidence and part of the formal hearing. And this also means that your mediator isn't going to disclose any information to the other side that you don't want them to, nor are they going to share anything with the administrative law judge about any sort of confidential discussions that were had as part of the mediation. Now, the purpose of this is so that parties can really be open and honest during these settlement discussions with the hope of being able to reach an agreement. So if you find yourself in an informal settlement conference, please feel free to be open with your mediator so that they can best help you get to a resolution. So when does an informal settlement conference take place? Today, we're mostly going to be talking about informal settlement conferences that occur as part of the unfair practice charge process. And so to understand when these conferences take place, we need to know a little bit more about the life of an unfair practice charge here at PERB. So on your screen, you'll see a flow chart that has sort of this initial part of the unfair practice charge process. It starts off with a charge being filed by a charging party against a responding party over an alleged violation of one of the laws that we administer here at PERB. Now that unfair practice charge, once it's filed, is going to be assigned to a board agent with the Office of the General Counsel who's going to be doing an investigation. They're going to be reviewing all of the filings and making a determination as to whether the charging or the unfair practice charge does state a potential legal violation or not. As part of that investigation, the charge could be withdrawn, or the charge could be dismissed, or the board agent assigned to the case could issue a complaint, which says, hey, looks like there could be a legal violation here. It kind of gets that charge moving along the PERB process. So once the complaint has been issued, the case is going to be assigned to a different board agent with the Office of the General Counsel who's going to conduct the mediation, the informal settlement conference. Now, this is a different board agent than the one who issued the complaint, so that we have sort of a new face coming in, a fresh set of eyes to really be able to be neutral between the charging party and the responding party and be able to facilitate a resolution via mediation. So at the informal settlement conference, if the parties reach a resolution, then the charge is withdrawn. That's the next step of our flow chart here. But if they don't reach a resolution, the case will move forward to a formal hearing before a PERB administrative law judge. That law judge will make a decision, and that decision could be appealed to the board itself, to California appellate courts, and beyond. And so that is the life of an unfair practice charge. Mediations take place in the middle there. So again, to sum it up, informal settlement conference takes place after the Office of the General Counsel has issued a complaint, but before the Division of Administrative Law and a PERB administrative law judge holds a formal hearing. But there are other situations where PERB might hold an informal settlement conference. So one example might be before a complaint has issued. So while it's still in that initial investigation process, the assigned board agent might think that this case could benefit from early resolution, and the parties might be able to reach an agreement better if it happens before that complaint has issued. And so we might hold an informal settlement conference then. We might also hold an informal settlement conference towards the end of that PERB unfair practice charge process. So let's say that the case proceeds to a formal hearing before an administrative law judge. That judge issues a decision that has a remedial order, right? They found a legal violation, they're issuing a remedial order. Let's say that that remedial order is back pay, right? As part of the process of making sure that the responding party complies with that remedial order to provide back pay, we might meet with the parties, with the charging party and with the respondent, and see if we can come to an agreement as to how that back pay is going to be calculated and how it's going to be issued to the employees who need back pay, right? So we might have an informal conference then to help them get to an agreement on how compliance is best carried out. We might also hold informal settlement conferences as part of a representation matter. So let's say that a union and an employer have a dispute as to which employees belong in a bargaining unit. We might meet with the parties to help them come to an agreement as to who's in and who's out of the unit. And finally, another example we have is as we might hold informal settlement conferences as part of strike line pass negotiations. So if a union is going on strike, an employer might come to us and say, hey, we get it, employees have the right to strike here, but we need some employees to stay behind in order to be able to safely provide our public services. So we might meet with the union and the employer to help them come to an agreement as to which employees might be staying behind and continuing to work as part of the strike, who those employees are, when those employees are going to work, and those types of things. So a lot of situations where PERB might hold an informal settlement conference, we're here to help the parties resolve their disputes. But today, we're mostly going to be talking about informal settlement conferences as part of the PERB unfair practice charge process. So once a case has been assigned to a PERB board agent with the Office of the General Counsel for an informal settlement conference, that PERB board agent is going to be selecting a date. Right? That's how we're going to be scheduling the informal settlement conference. They're going to select a date, and then they're going to issue a notice of informal conference to the parties. And that notice of informal conference is going to include the date and time of the conference. It's going to include information about the format of the conference and instructions for requesting to reschedule the conference if the date that the board agent has selected doesn't work. Now, I will say that our informal settlement conferences are usually scheduled for 4 to 8 weeks after the complaint has issued. This is to give the parties enough time to be able to put this in their calendars, to schedule it, to get all the people that they need there, and also be able to review the case, to be able to think about their settlement positions, and to really be prepared and come in ready for the informal settlement conference. So when the mediator issues the notice of informal settlement conference, this is a little bit about what it's going to look like, right? So on your screen here, you have a sample notice of informal settlement conference. It's going to be a document. It's going to be on PERB letterhead, CSC State of California Public Employment Relations Board. We've got our PERB logo over there. At the top on the left, you're going to have the parties. Here for this sample, we've got Lindsay Kramer as the charging party versus the California Technical University as the respondent. To the right of that, we have the case number, LACE 8008080H. This is a fake case. Please don't look it up. It's going to say notice of informal conference, right? So you know who the parties are, what this document is, what it's pertaining to. And the first sentence of that is going to say, please take notice that on February 28th, 2025, beginning at 10 a.m. at the Public Employment Relations Board, Sacramento Regional Office, 1031 18th Street, Sacramento, California, an informal conference will be held pursuant to California Code of Regulations, Title 8, Section 32650, on an unfair practice complaint issued by the Public Employment Relations Board, PERB, against the above named respondent. So this notice is going to tell you who the parties are, what case it is, when and where this conference is going to be taking place. And it really puts you on notice as to, hey, here's what we're going to be talking about and when. Our PERB informal settlement conferences can be held a variety of ways. Typically, we are holding our informal settlement conferences right now virtually. This means it's going to be via a video conferencing platform such as Microsoft Teams or Zoom, where everyone can tune in from wherever their offices is, or wherever they're doing their work for that day. Sometimes we still hold them via telephone conference calls, where everyone dials in to the same phone line, *6 to unmute yourself, sort of more classic distance conference. And then we do also still hold them in person in our regional offices. We have regional offices here in Sacramento, in Oakland, and in Glendale. And so sometimes we will hold them in person in our conference rooms and meeting rooms in an office. Now, the format of the informal settlement conferences is really up to the discretion of the assigned mediator. Like I said, still mostly virtual, but however the conference is going to be held, your assigned mediator will be sending you information about how to attend, how to log in, provide you a conference link if needed, and they'll go through all of that with you. So now that we've scheduled the informal settlement conference, what actually happens during these conferences? Each conference is going to look a little bit different. It's really going to depend on the style of the mediator. It's going to depend on the negotiating style of the parties. It's going to depend on the issue, right? Some issues are just going to need to be negotiated a little bit differently depending on who's involved and what's at stake. So really, no two informal settlement conferences are going to look the same. But here's what a typical informal settlement conference might look like. So typically, The parties, charging party and respondent and the mediator, are all going to start in joint session. That means everyone's going to be in the same room together. And the mediator might use this time while everyone's together to facilitate introductions of the parties, right? Let everyone go around, say who they are, what their role is with the employer or the organization. And this really allows everyone to understand, who's in the room, right? Like who's negotiating this, who's a part of this, and gets everyone a little more comfortable with being able to reach a resolution once they know who everyone is. The mediator might go over the structure of the mediation, any ground rules, say, hey, here's what today is going to look like, here's the format we're going to follow, right? Let everyone understand what the day is going to look like. And then the mediator might ask for an initial exchange of proposals if the parties are ready. Right? So if someone comes prepared with an initial proposal that they want to share while they're in joint session, they can do that. And it gives the other side the opportunity to be able to ask any clarifying questions, make any comments, while everyone is all together. Now, I mentioned ground rules. And so here are some things that the mediator might want to go over with everyone before the mediation really gets started. First up, confidentiality. So I mentioned earlier that our informal settlement conferences are confidential under the evidence code. Mediator might provide a reminder of that, right? Remind everyone, hey, please be open in this space so that we can get to a resolution, because everything is confidential. The mediator might not always be in the room with you during the course of the mediation, so they might talk to you about methods of communication, right? Whether they like to be contacted via email, via text, via the chat in the video conferencing platform. So they'll talk to you about best ways to communicate during the conference. And they might go over timelines, right? So like basically what the flow of the day is going to look like. If they need to talk about any breaks in the day, such as for lunch, if there are going to be any hard stops. We might typically plan for these conferences to last all day, but sometimes we need to end at 4 o'clock for one reason or another. We'll go over kind of what that timing is going to look like. Might also go over length of time for caucusing, right? Mediator might say, hey, all of our caucuses are going to start off at 15 minutes, right? And then if we need to have more time, we can address it then. But this way, they might set these kind of guidelines to help the mediation continue to move forward efficiently throughout the day. So after the parties start in joint session, and once we've discussed everything that we need to discuss while everyone is all together, then the mediator might move the parties into their own private breakout rooms. So we'll have a breakout room that has just the charging party, and we'll have another room over here that has just the respondent, and so it's just the individual parties amongst themselves, and the mediator can move between those rooms. So these rooms are really an opportunity to be able to have a discussion amongst your own party or with the mediator without having the other side present to be able to hear what those conversations are. While the parties are in these breakout rooms, they'll often discuss settlement proposals, right? Drafting up those proposals, deciding what it is that they want to offer or how they feel about proposals that they've received. They could be talking about the strengths and weaknesses of their case, right? And really being open about, hey, here's where our case isn't looking so good, and be able to have those conversations, be able to assess their settlement position in relation to what those weaknesses are without having the other side hear it. And you can also talk about concerns about the issues, talk about your settlement priorities, really figure out what's important, where you want to press, where you don't want to press. And again, this is really a safe space for the parties to have these really frank discussions to figure out what's the best way to get to a resolution here. So what is the mediator's role during all of this? The mediator's role is really to facilitate settlement discussions between the parties by helping parties draft settlement proposals, right? So we've seen quite a few of these informal settlement conferences. We've seen a lot of settlement agreements. We might be able to provide some suggestions of language that we think might be acceptable to both parties, or that might be able to help the parties accomplish exactly what it is they're trying to accomplish with this settlement agreement. Or we might even just be providing a template that the parties can plug their terms into and really get the ball rolling on finalizing a settlement agreement. Your mediator might also provide a neutral evaluation, right? So here at PERB, our board agents are experts in the collective bargaining law here. We've seen a lot of cases, and so we can provide you with a neutral evaluation saying, hey, you know, I've read the cases, I've heard you say what the facts are. Based on my understanding of the PERB case law, right, here's how I think your case is going to shake out. Here's where I think an administrative law judge, you know, might fall on these issues. Here's where I think you're really going to have to focus on presenting evidence on this particular issue, right? We can provide those sort of neutral evaluations to help you assess your own position. And the mediator is also going to be passing proposals quite literally between parties, right? We're going to be moving from room to room, saying, hey, you know, here's charging parties' proposal. These are the terms that they're asking for. And your mediator can answer clarifying questions that you may have about a proposal, be able to explain, oh, here's why they chose this language over this language, or asked for this number instead of this number, right? Your mediator can be able to, or is able to explain those proposals as they're passing them along. And so the mediator is going to do this, right? We're going to work with the parties. We're going to be moving between these breakout rooms until the parties reach an agreement or reach a point where settlement discussions really aren't going to be productive anymore. And then we're going to send the case on its way to the next step of the process. So here's what the mediator doesn't do. Right? The mediator does not represent either party. Here at PERB, we're a neutral agency, and we don't provide legal representation. And so even though the mediator is passing proposals, right? They might be taking your proposal and conveying it to the other side. We're not representing you as part of that process, right? We're not representing your interest. We're not advocating for one side's proposal or the other. Our role here really is just to facilitate that conversation, pass the information along, and be able to help the parties from a neutral standpoint reach a resolution. The mediator also doesn't give legal advice. We might provide those neutral evaluations of our understanding of the law, but we're not here to provide any sort of legal advice as to what steps you should or shouldn't be taking. Nor does the mediator make any factual or legal determinations. So these are informal settlement conferences, not formal hearings, right? As part of this process, you're not going to be presenting witness testimony or bringing up all of your documentation, all of your evidence, right? The mediator isn't going to be sitting there and saying, well, hey, you know, I think this witness is or isn't credible, right? Or this fact is or isn't true. That's for the administrative law judge later on. Your mediator, again, here is really to just facilitate discussions, not make any decisions, help the parties reach a resolution. Now, the best case scenario after an informal settlement conference is that the parties reach a fully executed settlement agreement, right? And so our goal is to reach an agreement that resolves the dispute that results in withdrawal of the unfair practice charge. And so this conference should end with a fully drafted settlement agreement, right? It's going to have all of the terms, all of the parties agree on all of the language, right? It is now fully finalized, everyone agrees. It should include withdrawal of the unfair practice charge. Now that could be either a clause in the settlement agreement that says charging party hereby withdraws unfair practice charge LACE 8080H. Or it might be something that looks along the lines of within 5 days of full execution of the settlement agreement, charging party will file with PERB a withdrawal of unfair practice charge number LACE 8080H. And after all of that, that document should be signed by both parties. Now, I do want to note that PERB does not enforce these settlement agreements, right? Like, we might help you get there, but we don't enforce these settlement agreements. We're not a party to these agreements. Your PERB mediator isn't going to be signing this document. This is really just a contract between the charging party and the respondent. And yeah, PERB's not part of that. Just happy to help you get there. So what if the parties don't reach an agreement, right? Not every informal settlement conference ends in an agreement. Sometimes the parties aren't there. Sometimes facts are just really strong for both sides. We get it. If the parties aren't able to reach an agreement during the conference, then the case is going to move forward to a formal hearing before a PERB administrative law judge. In order to help the law judge schedule that hearing, your mediator might ask you for a few questions at the end of the conference. They might ask you about your availability for hearing. So our judges are typically scheduling hearings about 2 to 4 months after the informal settlement conference is held. So they're going to ask you about your availability during that time so the judge knows what dates they're working with. Your mediator might ask you, how many witnesses are you planning to call during the hearing? This really helps for scheduling how many days of hearing this case is going to need. They might ask you about your preferred format, whether you prefer a hearing to be held virtually or in person. I will say that most of our hearings are being held virtually still at the time, but the format is up to the discretion of the assigned administrative law judge. And so you can let them know what your preferences are one way or the other. And even if the parties don't settle at the informal settlement conference, don't give up, right? Like, there's always room to settle after the informal settlement conference and up to the point before the administrative law judge issues their decision, right? I said this could be a 2 to 4 month period. There might be changes in circumstances, right? Where maybe people's settlement priorities have shifted now because things have changed. Or as parties are preparing for the hearing, there might be some new information that comes to light where maybe someone realizes, oh, hey, maybe our case isn't as strong as we thought it once was, right? Now that we've talked to someone who might be a witness as part of the hearing. And so now they might be a little more interested in settling than they were before, right? So always keep an open mind. Always think about, hey, is there a new opportunity to settle, to resolve this case before going to a hearing? And if you think that you could benefit from another PERB informal settlement conference, just let us know, and we'll figure out how to help you. So I've talked a lot about what an informal settlement conference looks like, but a video is worth 1,000 words. So we do have a demonstration video on informal settlement conferences on our website. It is there at perb.ca.gov/training-videos/informal-conferences/ you can see the link there on the screen. And this demonstration is going to show you kind of what a whole informal settlement conference looks like, right? From the very start, when the parties start off in joint session and are going through those introductions, all the way to passing proposals and then having that fully executed and signed agreement at the end. So I do encourage you to take a look at that. On your screen here, there is a screenshot from that video where you can see here at the head of the table, we have a mediator, and then to the left of that mediator, we've got parties. If you watch the video, you'll know that that is charging party and her friend joining the informal settlement conference. So I do encourage you to take a look at that to see what it looks like in action. All right, so let's say that you are scheduled for an informal settlement conference. You've got one coming up. How should you prepare? Successful informal conferences really do require some legwork ahead of time, right? And a big part of this is knowing the case. So in your case file, as part of this unfair practice charge, you're going to have a few documents by this point. You're going to have the unfair practice charge itself. You're probably going to have a position statement from the respondent going over what their view of the case is. You're going to have a complaint that goes over, list out, here are the allegations that this is proceeding forward on. And so really read through all of that, get an understanding of what information is part of this case and what is being acted on. You might want to talk to witnesses, right? Figure out what happened from the people who were there. Right? See if they have any key information that's going to help you form an understanding of your position or the strengths and weaknesses or what might be needed to settle this. You'll also want to learn the facts from both sides, right? We have a dispute, that's why we're here before PERB. The parties disagree as to perhaps what happened or the legality of it. And so to be able to formulate your settlement position, really think about what the facts are from the other side. What are their strengths, right? Why they might think that they're in the right here. You can also research relevant case law. So I mentioned earlier that on our website, we do have our precedential board decisions. You can read through those there, get a sense of what the law is right now, right? What has been the board's findings recently about cases that are similar to yours? See if maybe there are other cases that have facts that are similar to yours and how the board has made a decision in those cases with similar facts. And that's also going to help you figure out what are the strengths and weaknesses of your case and really what your settlement position should be. You should also be thinking about settlement options before coming into the informal settlement conference. You want to consider what your settlement priorities are, right? If this is a case where an employee was terminated, are you looking for reinstatement? Are you looking for some sort of monetary compensation like back pay? If this is a case where an employer has allegedly made a unilateral change to working conditions without negotiating with the union, is the union looking for an opportunity to bargain over that change, right? Are you looking for something else? Figure out what it is that you want as part of settlement, and then also figure out kind of the hierarchy of it, right? Like, what are your priorities in settlement? And so maybe reinstatement is more important than back pay, right? It's important to know what you're looking for and how important everything is in reaching a settlement to you. And with that, it's also important to know your bottom line, right? What is the absolute minimum that you're willing to accept as part of a settlement? And so maybe you go into settlement, you start off with a $500 proposal, right? That's your opening offer. But deep down, you know that you're really willing to accept, say, $100, right? It's important to know what your bottom lines are, what you're willing to walk away with in order to get this agreement done. It's also important to know what's going to happen if you don't settle, right? So if you don't settle at the informal settlement conference, like I said, this case is going to move forward to a formal hearing before a PERB administrative law judge. Are you prepared to put on that hearing? Are you prepared to put on to bring witnesses to the stand, to ask them questions, to put forward all of your evidence, your documents, all of those emails? Are you ready to bring all of that forward, to put on that case before a judge, and then potentially lose, where you could potentially walk away with nothing? And if you do win at hearing, do you know what those remedies are that you're going to get? And so if you have a case where the typical remedies don't include money, are you willing to accept that you might not get any money out of a resolution or out of this case, even if you do win? So it's important to know, what the worst case scenario is, what the best case scenario is if this does proceed to hearing, so that you can really formulate what a realistic settlement might look like for you. Before coming into the informal settlement conference, you can also draft a settlement proposal, right? We encourage you to have your initial proposal coming in to the conference ready to go. And that proposal should include all of the terms that you are initially asking for, right? Know everything that you want ahead of time, put it all out on the table so everyone knows what we're all working with. And that proposal should also include some room for you to negotiate, right? Don't start your proposal with your bottom line. Have a little bit of wiggle room in there so that there's room for perhaps you to give up something for the other side's priorities, or for the other side to give up something for your priorities. Leave room to negotiate so that the parties can come to an agreement that everyone is happy with. It's also important to communicate with everyone else before your informal settlement conference. You can talk with your mediator, right? Give them a call ahead of time. Say, hey, here's what my initial proposal is going to be. Here are my settlement priorities. Here are some issues that I might see arising as we engage in these discussions. These discussions with your mediator really help them be able to understand the positions of the parties ahead of time, be able to effectively communicate proposals and positions. And as a reminder, these early conversations with the mediator are still confidential. So please feel free to be open with them even at this point. You can also talk to your client, right? If you're a representative or if you're an attorney, talk to your client and really get a sense of what they think happened and what it is that they want out of settlement, right? Know what their priorities are and know what it is that they're willing to give up as part of this resolution. And you can also talk with the other side, right? Give the other side's representative a call, say, hey, here's what we're looking at for settlement, right? Or here's what we're not willing to negotiate, right? Maybe a representative knows that from the get-go, say reinstatement isn't negotiable, right? They won't be able to agree to any settlement that involves reinstatement. You can have those conversations ahead of time with the other side so that everyone knows where they stand, and to be able to have more effective and efficient negotiations once you get into the informal settlement conference itself. So now that you've prepared, you're in the informal settlement conference, how do you make the most of it once you're there? First, bring authority to settle, right? If you've done all of this prep work ahead of time, you probably know what your proposals are going to look like. You know what kinds of terms the parties are going to be discussing. Bring someone with you to the informal settlement conference who has the authority to sign off on those terms, right? To say, yes, we can agree to this, we can sign, we can resolve this and be done, right? Have those people there in the room with you so that you can really engage in those conversations, know where that wiggle room is, and then be able to close the deal. Otherwise, if you get a proposal and you say, hey, we actually need to talk to these 5 other people, 2 of which are on vacation right now, right? That's really just going to delay the process and draw it out, prevent the parties from getting to a resolution quickly and efficiently. Also, feel free to get creative with proposals, right? The beauty of these settlement agreements is that they are a contract between the parties. And so really the parties can agree to whatever works for them. So perhaps, this dispute is part of a bigger issue, right? Something outside of just PERB labor disputes. And so maybe the parties want to come up with a resolution that resolves multiple disputes all at once that also just happens to include the PERB one. Get creative with it. You can agree to terms in the settlement agreement that go outside and beyond the typical remedies that you might get if this case were to go to a formal hearing before a PERB administrative law judge, right? Really, it's whatever the parties are open to resolve this dispute. So get creative. You know what's going on the ground, and feel free to bring in all of those ideas that are really just going to help the parties move forward and improve their collective bargaining relationship. As part of that, it's also really important to have an open mind. And so someone might come in with a proposal that is very different from maybe the proposal that you had initially given. Or a proposal doesn't look like, what the kinds of terms that you had in mind for these settlement negotiations, but be open. Listen, hear the rationale for providing that proposal, because maybe, even though it's something you didn't think of, maybe it really will be a good resolution to this dispute. And finally, be polite and professional during these informal settlement conferences. We know that they can get a little tense. Sometimes you might hear a proposal that you don't like, or you might hear an evaluation from your mediator that you don't agree with. So feel free to take a minute if you need to. But we are all here with the same goal in mind, which is to reach a resolution in this dispute. And so hopefully, if we are all kind to each other, we come in with those open minds, we can be able to get you to a resolution. And with that, thank you so much. Hope you learned a lot about informal settlement conferences. If you have any questions, again, about this webinar or any of PERB's processes, you can email us at perbquestions@perb.ca.gov. And we hope that you tune in for our next webinar. It's going to be on July 7th, and it's going to be a panel discussion with the Division of Administrative Law. Thank you.